Okay, so now for harassment and victimisation. Under Section 26 of the Equality Act, a person harasses another person if they violate their dignity or they create an intimidating, hostile, degrading, humiliating, or offensive environment. So, just as long as you have one of those things, you can ground a case of harassment in the workplace. It's also worth noting that the Protection of Harassment Act, 1997, Section 1, creates a freestanding tort which operates outside of the workplace as well. It says that you must not harass somebody, and you are harassing somebody if a reasonable person would know or should know that the conduct being done is harassment. But back into the workplace, Section 40 says that an employer must not harass a person who is an employee or somebody who applies for a job. A couple of illustrations of this, very straightforward. And first one is about an offensive environment. Thane in the London School of Economics sees a claimant who works in the maintenance department. She's a woman. She has to work where the male colleagues have put up pornography on the walls, and she's got to do the sign-in at work in the male change room. So this was held to be creating a hostile environment, so she won her claim for harassment. Another claim or another example of harassment is Madrowski and Guys and St Thomas's NHS Trust, which of course is affiliated to King's College London. So LSE and King's not doing too well here on the harassment cases. Madrowski claims that the trust was liable for the conduct of the manager under the Protection from Harassment Act. So this is before the Equality Act 2010, obviously. And what Madrowski was subjected to was homophobic mockery. Lord Nichols held that there was vicarious liability for employees of the trust harassing other employees, and so that included a supervisor. Under Section 109, there is a defence for employees. So Section 109 says that employers are liable, but employers have a defence if they took all reasonable steps to prevent harassment, discrimination, and so on. Now, employers are also liable, not just for their employees, but for third parties. And this has gone back and forth a bit in recent years in the law. For instance, what happened is that the Conservative government, in its wisdom, before removed Section 40 almost entirely, or they just left quite a lot of it blank. And so we had court cases trying to work out what on earth was meant to be the position in the law. Bessong and Penning Healthcare NHS Foundation Trust held that third-party harassment does not make an employer liable unless there is discriminatory conduct by the employer in their failure to take steps to prevent the harassment. Now, Section 40A has reversed Bessong, so that an employer has to take all reasonable steps to prevent sexual harassment. And if they don't do that, then there can be a 25% uplift in compensation receivable by the claimant. This was from an Act of Parliament in 2023. Now Section 40 and everything else actually is being amended again by the Employment Rights Bill. Assuming that the Employment Rights Bill comes in its current form into force, then Section 40 will say that an employer must not permit a third party to harass employees and must take all reasonable steps to prevent that. And Section 40B will give the Secretary of State power to write regulations on what taking reasonable steps would mean. And reasonable steps, as the next case, Galen illustrates, is more than just giving people EDI training. So in Galen, the Employment Appeal Tribunal held that the reasonable steps defence that an employer took, the reasonable steps defence was not available to an employer who had simply given training to staff, but had done the training years ago on equality, and according to the tribunal, the appeal tribunal, it had gone stale. So it was no defence that some random training years ago had been given when colleagues made racist remarks to employees of the employer. You've got to have something more credible than that. Now then on to victimisation. Section 27 says that a person victimises another if they subject them to detriment because of a protected act. And basically a protected act is doing anything in relation or making allegation in relation to the Equality Act 2010, so long as it is in good faith and the claim is actually true. So if you bring proceedings under the Act, if you give evidence, if you do anything in connection with the Act, or you make an allegation about a contravention of the Act, and you are subjected to detriment, this is unlawful victimisation under Section 27. But it's not unlawful victimisation if the allegation being made is false, or the person is acting in bad faith, and the person is acting in bad faith. So a couple of illustrations of victimisation straightforwardly. First is in a case called Khan and Chief Constable of West Yorkshire Police. This is where the employer refused to give a reference to Khan, who was bringing a claim for race discrimination. It was held not to be victimisation, not to be unlawful, because even though it was bad that Khan didn't get, or from his perspective it was bad that he didn't get a reference from the employer that he was indeed suing, the House of Lords said that the employer has a legitimate interest in not prejudicing its own position in litigation by giving a reference that would undermine things that it later had to say that might be negative about Khan in legal proceedings. A case where the claimants win on victimisation is St Helens Metropolitan Borough Council and Derbyshire. And this was a group of 470 dinner ladies who claimed that they were being paid unequally by the council. They had started their equal pay claim, and the council sent them a letter that if they continued with their equal pay claim, this might mean that there had to be budget cuts, which would mean fewer school dinners for children going hungry, and that there might have to be redundancies. The House of Lords and Lord Neuberger, who's giving the lead judgment, holds that this is victimisation and it is detriment, and it's detriment wherever a reasonable person would consider that it's detriment. So that's the way that you reconcile this case with Khan. A reasonable person would understand that the employer doesn't need to give a reference when they're being sued by the claimant. There's more to it than that, but as a basic position, and a reasonable person would see that threats to cut food for children is detriment. Okay, so that is victimisation. Putting all of this together, what reforms might we want to introduce if we wanted to bring UK discrimination law, at least in the fields of direct discrimination, protected characteristics, up to international standards? The first thing that we could do is codify the general principle of equal treatment. Yes, it's arguably there at common law, but it's very different to have it in statute. And create an open-ended list of protected characteristics like in the European Convention, including things such as class, caste, property, and so on. Second thing, there's a big need for employment tribunal cases not to go on so long. When we look at how long some of these cases last, it's many, many years. Can be well over a year at the moment before people get even a tribunal hearing. So there's a need for investment in employment tribunals to resolve claims more quickly, and also for tribunals to have powers to award effective remedies. For instance, tracing employers who do a runner or freezing their assets. So that's really important. Also in the interests of good employers to make sure that the process is quick, doesn't drag on a long time, which can only be to the benefit of lawyers charging fees. Third thing is to prevent discrimination in childcare leave. So, the same ideas that we talked about when we did working time. Require employers to raise and equalise paid parental leave. Of course, it's better for the child if both parents are there, mother and father, or two fathers or two mothers, not have one parent wedded to the employer. And this is so important to combat the gender pay gap, to make sure that parents are doing equal parenting and equal time in their careers. And the fourth thing is to strengthen sector-wide collective bargaining and ensure that there's action plans in collective agreements for workplaces to combat the gender pay gap, race pay gap, and the overall pay gaps as well. And we're going to talk much more about these things and all things related to this when we do indirect discrimination and positive action next.